Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda, and the goal is to learn more about the Constitution to support my students who are taking common law and civil rights lawsuits. This is a supplemental way for them to review and to introduce the material before they read. For all the rest of us, it's about learning about the Constitution so that we may advocate for and seek justice and more justice. And justice comes by learning and learning about the promises of the Constitution. So in my last clip, I introduced the concept of privacy rights. And I pointed out to you that the Constitution has specific express rights in the Bill of Rights, but the court has determined that there's a penumbra of other rights, that each of the individual rights working individually and together cast out shadows. And within those shadows, we find the privacy rights, although privacy is not specifically mentioned in the Bill of Rights. Now, what I did last time was I pitched to you a number of hypotheticals, and the hypotheticals came from actual cases. I wanted you to think about all of these potential, and the court has interpreted that some of them exist as privacy rights, and to ask yourself, which ones do you believe should be protected as a privacy right under the Constitution? Now, before we start going through the hypotheticals, let me caution you on something. Let me caution you. Even if the court determines that there is a privacy right for whatever you are asserting or arguing for, even if the court says you have that privacy right, that does not mean that privacy right is absolute. Remember, a couple of videos ago, we talked about that generally, not always, generally, the court uses heightened review. What you talking about? What you talking about, government? When government infringes on certain rights. But even if the court uses heightened review, the governmental action that may infringe on your proclaimed privacy right, the governmental action may still be determined to be valid. Government may have a compelling governmental interest, and what it is doing, the court may say is narrowly tailored to that interest. So even if the court says, yes, you have a privacy right, it does not mean under the interpretation of the court that your right is an absolute right. The other thing that I will point to in a minute, that even though the general rule is that these privacy rights cannot be infringed upon unless the court meets that heightened review, the court doesn't always follow that. And we'll see in just a moment. Now, in the text, below this video, I give you the names of all of these cases and the dates. They are all US Supreme Court cases. So you can Google them. And for my students, they're in your materials, or you can check them out on Westlaw, just to verify that what I'm about to tell you is indeed the truth. Well, indeed the truth according to the court. Now, I asked you, did you think that married couples should have a privacy right to use contraceptives if they so choose? Is that a right that ought to be protected within the penumbra, the shadows of other constitutional rights? And in 1965, the court said, yes, Griswold versus Connecticut. The court said you cannot criminalize or make it unlawful for married couples to use contraceptives. It is protected. That right is protected under the penumbra. Now, some of the justices did some really interesting opinions. One justice said that this law, anyway, would be unenforceable. He said, what is the police going to do? Search the marital bedroom for telltale signs of contraceptives? He got a little raw there, right? And another justice who disagreed, this other justice thought that the government should be able to keep married couples from using contraceptives. The justice said, I like my privacy as much as the next person. But I'm going to tell you that the privacy right, according to that justice, does not appear in the text of the Constitution. And even though a law may be silly, as long as the privacy right does not appear by name in the text of the Constitution, government has a right to intrude upon it. But that was not the majority view. Married couples, the majority view was there was such a right to use contraceptives under this privacy penumbra. Well, look, after married couples got their right to use contraceptives, then single people said, well, what about us? Shouldn't single people? And the government said, no, in the case, I don't have it mentioned. There it is, Eisenstadt versus Baird in 1972. The court said, you can't tell single people, unmarried people, that would be treating them unequally from married persons. So the court determined that just like married couples, unmarried couples ought to also have the right, well, let me go back. Unmarried male-female couples ought to also have the certain rights of sexual intimacy, including the right to use contraceptives. When I went back, because we're going to get in a moment to the Bowers case, I said unmarried couples, and we know that even in 1972, there were still restrictions on gay couples. Okay, now, so what about an interracial couple? Well, it wasn't just a TV show. It was a real case with real people, Loving versus Virginia. A white male, a Black female, many years ago, brought suit in 1967 to protect their interracial marriage. Look, they had married outside the state of Virginia and then wanted to move back home. So they're home, as the story goes, in their bedroom, and law enforcement comes in and says, you're breaking the law. It's against the law for a white man and a Black female to be engaged in this type of conduct in the bedroom. And then Mrs. Loving said, oh no, we're not single, we're married, and showed him the marriage license that she had on the wall. And the police said, now you're really gonna be arrested because you're violating the law. The law that in Virginia, they did not want white individuals to marry people who were not white. So what did the court say about that? The court said, of course, there is a right of privacy, that the penumbra of privacy includes the right to marry a person of the opposite sex who you choose, even if that person is of a different race. So you see how the penumbra of privacy rights is growing, the shadow is becoming bigger to include more rights in this penumbra, in these zones of privacy. So in the 1970s, we have Roe versus Wade, the case addressing whether women have a right to choose to have an abortion. And the court did some interesting things in that case. For one thing, the court said it was not going to define when life begins. It says if the ministers and the doctors cannot agree, then the court said it is not going to try to make that determination. But the court held in Roe versus Wade and later reaffirmed in the Casey case, Planned Parenthood versus Casey, that women do indeed have a right to terminate pregnancy. Now, at the beginning stages of the pregnancy, there's a greater right in this penumbra. As the pregnancy advances, the court said that the state could exercise more, I guess you would say more authority for reasons related to health or safety. But in the Casey case, the court sort of changed the test a bit, although it reaffirmed Roe versus Wade. It said that the government could not impose an undue burden on a woman's right to choose, an undue burden. So is there a right to choose to terminate a pregnancy within the penumbra? The court says yes, but you have to look at what government is doing according to the court to see if it is indeed placing an undue burden on a woman's right to choose. Look, so I told you about the grandmother who just wanted to live in the house with her son and then a grandson from that son and then another grandson. And the city of East Cleveland said, no, we are favoring nuclear families, not this type of extended family model. So she brought suit. The court said, of course, you have a right of privacy, that privacy rights are not just for nuclear families. They talked about the extended family tradition, especially as it is in many cultures and many racial groups. So the court said, of course, your privacy right to reside with in your home in this neighborhood is within the right of privacy. It was really interesting. You know what one justice said? He said, oh, grandmother, she can live with them. This justice dissented. He did not want her to have a privacy right. He said, grandmother, you can live with them, just not in this neighborhood. So it's not infringing on your right. You would just have to move. But the majority did not agree with that. They said that there was this right of privacy to exist in this non-nuclear, non-traditional for some people arrangement for this grandmother. And of course, there was even a right of privacy found for individuals who are incarcerated in prison to marry. But then the court said, yes, you have a right to marry, but the prison may want to, has the authority to impose restrictions. So in other words, there may be a right to marry, but the prison may set up the parameters for that. There may be a right to marry while one is in prison, but the court didn't say there was a right to consummate that marriage. You understand what I mean? So at least what the court meant. So I also talked to you about Glucksberg in terms of health. You know, that case, Washington versus Glucksberg, is an amazing case to read about whether one has a right to assisted suicide. In class, it always leads to very intense discussions and learning experiences. But the question was whether or not an individual had a right to suicide, to assisted suicide. Now, that opinion is so fascinating because in the concurring opinions, a lot of the justices keep referring back to Justice Sandra Day O'Connor, who was on the court at that time. Justice O'Connor was the first female to serve as a Supreme Court justice. And during the time of that opinion, her husband had been very sick. And so you can see that the other justices are trying to defer to her given that she has a unique experience about taking care of a loved one who is very ill. Well, not a unique experience, I would say, but rather she was experiencing that at that particular time. So that opinion is interesting because it seems, I'm just going to say it seems that there is a right to refuse medical treatment. It seems that there is a right to hospice care in the penumbra. Whether there is a constitutional right to suicide or a constitutional right to assisted suicide, a federal right, is very doubtful. Now, let me say, this is under the federal Constitution. The federal Constitution imposes the floor. A state may say, well, we want to have some process, some laws to allow for death with dignity, a death with dignity act, or with certain types of assisted suicide being allowed if the person has a terminal illness. So remember, just because the court didn't say there was a federal right does not mean there may not be a state right that grants more rights than what's found in the penumbra. Just a couple more cases. So earlier, when we were talking about the rights of married couples, we talked about male-female couples, interracial couples, couples where one is incarcerated. What about same-sex couples? Well, going all the way back to Bowers, as mentioned at the bottom, the court did not want to recognize this right to same-sex intimacy in consensual relationships. But the court overturned that in Lawrence and recognized, so it plays within this penumbra. Bowers said same-sex couples that expect those rights of privacy and intimacy is outside the penumbra. Lawrence brought those rights into the penumbra of privacy. And as many of you know, later the court in Obergefell, I had trouble getting it out, versus Hodges, the court said that same-sex marriage was constitutionally protected. So I'm sure you agree with some of these, many of these. You may disagree with some of these. But then what I want you to think about as you discuss this with your family and friends and debate this idea of privacy and bodily integrity, if this is the penumbra, and if you want all of the rights here, but you don't want these, if you start to contract the penumbra, what happens with it? So as you think about privacy rights, also think about when shifts and changes are made to the penumbra, what happens to some of the other rights? And that is just something to give pause to and consideration to as we continue with our ongoing debates about bodily integrity and privacy rights and governmental authority. Again, this is a taste of justice with Professor Angela Mae Kupenda. My goal is to both engage my students further, who I am teaching remotely, and to give them a little bit more as they read the lengthy opinions and prepare for class. And my goal is to also participate in learning with all of you. The more we learn, the more enlightenment we can have, and the closer we can step to realizing the full promises of the preamble of the Constitution. And one of those promises says that the goal is to establish justice. So here, I'm just trying to bring a taste of that justice. I'm a professor at Mississippi College School of Law, but all interpretations and views expressed are my own and not those of my school necessarily or of my students. So thank you again for joining me on constitutional law, probably it may be a week before I come back with common law, but I will be coming back with some more clips relating to civil rights lawsuits. Thank you, and you take care. Oh, remember to subscribe and sign up for notifications. Okay, bye.